Namaste, welcome to Up Close with Upward. Today we have a very special guest who's been in the news of late because of his very active role in the Gyanwapi Temple case. But it is not that he has become a household name only now. In fact, the start of his career was with his involvement in various civilizational battles, starting from the Ram Janmabhoomi case, in which he got involved along with his illustrious father, Shri Hari Shankar Jain. So Vishnu Shankar Jain is the spokesperson for the Hindu Front for Justice, and as I said, he started his legal practice in 2010, and from 2016 he's been an advocate at the Supreme Court of India. Welcome, Vishnuji.
Thank you.
There are about 102 cases which you, as well as your father, together or independently, have been a part of, and you are representing the Hindu side before the court. So, what are these 102 cases? I mean, just give us some few important examples.
These 102 cases are a classic example of the injustice which has been meted out to the members of the majority community in this country. And if I may give some examples, one of the most prominent cases which we have done and which has impacted the society at large is the withdrawal of prosecution by the Akhilesh Yadav government on the people who belong to the Muslim community and against whom there were serious charges of terror. So they were terror charges were of a serial blast in Varanasi, Sankat Mochan, in Lucknow Civil Court, and other places also in across UP. So when the Akhilesh Yadav government in 2013, in 2012, the election was conducted in 2012, and they had a particular election manifesto that when they'll come to power, they will withdraw the cases against innocent Muslim youth, was the word which was used in their order. Then we challenged that order when they passed an order under section 321 of the CRPC, taking a decision that they are going to withdraw the case and no more prosecution will be done. So we said that first of all, this decision is completely arbitrary and illegal for the very glaring reason that these are all cases of UAPA. And as per section 321 of the CRPC, the central government has the power to withdraw the cases, not the state government. So what you have done, first of all, you have fooled the entire society and you have taken votes on this issue. And second of all, you don't have power ultimately. You don't have power to withdraw these cases. So the matter was referred to 3 judges bench of the Allahabad High Court. My father Hari Shankar Jain and I assisted him. We both argued this matter threadbare, and the conclusion was that yes, under section 321 CRPC, these kind of cases cannot be withdrawn by the state government. Only central government has the power, and they quashed the order of Akhilesh Yadav government. Against this, they went to the Supreme Court, and till date there is no stay, and many of them out of those 20 accused have been convicted. So this is one of our cases. Then one very important case which fascinated me to join this legal career was my father contesting the case of Sonia Gandhi, where he challenged the citizenship of Sonia Gandhi on the ground that first of all, section 5 of the Citizenship Act, which gives a right to an individual to get citizenship on account of his or her marriage, we said that that is unconstitutional. Number one. Second, we said that Sonia Gandhi is not the citizen of India. She is Indian citizen. There's a distinction between citizen of India and Indian citizen. And Justice Lahoti was heading the bench at that point of time before the Supreme Court. And at para 20 of this reported judgment, Hari Shankar Jain versus Sonia Gandhi, he noted that we appreciate the forensic ability of the learned lawyer, but at this point of time, we cannot decide this issue. So the 4 issues were framed in that case, and all out of 4 issues, 3 issues we won in Sonia Gandhi's case. But they said that since there is no evidence, therefore we are rejecting the plea. But that point of time we didn't file a review because the question was there was not even a stage of evidence. When we filed the election petition in the Lucknow bench of the Allahabad High Court, Sonia Gandhi filed an application under Order 7 Rule 11 saying it's not maintainable. And against that maintainability issue, the matter travelled to the Supreme Court. So the stage of evidence has also not come. Second very important facet in Sonia Gandhi's case was,
So just to intervene, I mean, this is very interesting. So what you're saying is that there is a distinction between someone born in India and the naturalized citizen of
Yes.
India. So that's the distinction.
that's called citizen of India.
Okay.
And those who acquired citizenship, they are called as Indian citizen.
Okay.
So this off word was determined, and this, if very interestingly, this off word was elaborately discussed in another judgment of the Supreme Court, where Mr. Hari Salve had argued threadbare in with regard to a bank case, and this only interpretation came by the Supreme Court that off means person who is born from here or who's elected person,
Right.
not someone who has been chosen.
Right.
So, like for example, Adnan Sami has taken citizenship. Just to give an example, Adnan Sami has taken citizenship of India. So he will not be called as citizen of India. He will be called as Indian citizen.
Right.
And what does all this discussion lead to? All this discussion leads to the conclusion that you are not fit and qualified to fight elections, because in the constitution, if you will see, the qualification to fight elections, the terminology which is used is citizen of India, not Indian citizen.
Right.
So this argument was raised by my father at that time, and it still gives me lot of goosebumps when I heard him as a child in the backbench of the Supreme Court. He said that I am not here to ask anything for myself. I am here to ask that when this country in future, if ever, is again brought down to slavery, it should not be on the judiciary of this country that they have not taken appropriate action at the appropriate point of time. It can so happen that at one point of time, Benazir Bhutto will come and marry someone in India and one day declare that Kashmir is given to the Pakistan. So he said that this is a matter of internal security.
Absolutely.
But at that point of time, I think the voices which were raised were curbed.
No, but I'm curious to know, when they say that there is no evidence, what kind of evidence are they looking for?
That's what I'm saying, that this was a very abrupt finding, in the sense that evidence has to come. That's what, when election petition is filed, it's like a civil suit. We had to lead evidence, but before the stage of evidence, they said that your suit is not maintainable. On what ground, we don't know. And against that order, we came to the Supreme Court, and Supreme Court also said there is no evidence. And we kept on arguing before the Supreme Court that stage of evidence has to come. Once this maintainability issue is decided, which we have satisfied before the Supreme Court, now the stage of evidence will come, and we have challenged the constitutional validity of that provision also, of the Citizenship Act, where it gives a right to a person to get citizenship on the basis of marriage. So all these issues had to be gone into, but it was never. It was just curbed. But anyways, as a lawyer, as a junior to to Mr. Hari Shankar Jain, I learned a lot. I learned how a lawyer can put forth his arguments, how a lawyer can be a nationalist, how a lawyer can argue on the core issues of internal security, and that ultimately gave me a lot of drive and courage to join the profession. I had no confusion in my mind that when I was doing law, that I have to join the profession. Apart from that, my father had challenged, first time in the Indian legal history, election of Rajya Sabha was declared as unconstitutional, because hardly election of Rajya Sabha is challenged in this country. So in reported judgment of my great grandfather, Nemchand Jain versus P.N. Shukla, Pashupati Nath Shukla, first time in the Indian legal history, election of Rajya Sabha was declared as illegal, because that time the argument was that the secretary of Vidhan Sabha is not an officer of the government, and it is violation of the Representation of People Act. So like this matter came to the Supreme Court. Justice O. Chinnappa Reddy was heading the bench. He also said the same thing, that your arguments are right, it's correct, but if we'll accept it, it will create a havoc. So the questions and the arguments which have been raised have remained unanswered in the past, and that gave me a lot of drive and courage to move forward. Then first time in the Indian legal history, a president proclamation was declared as unconstitutional when Kalyan Singh was the chief minister, and president rule was declared in UP. He stepped down, and that presidential proclamation was challenged by my father on the ground that there is a difference between government of Uttar Pradesh and government for Uttar Pradesh. And Justice Karju was heading the bench. 3 judges of the Allahabad High Court declared the presidential proclamation as unconstitutional, first time in the Indian legal history, and he again came to power. So these are the incidents and cases which affected the people at large, which asked for core issues, then issues of love jihad, issues of atrocities on Hindus in the state of UP, all these issues where a girl is Hindu,
Right.
a boy is a Muslim, and they are brought to court, habeas corpus was filed, so we are rescuing them. Apart from that, if there is any temple destroyed, if there is any law and order issue, I saw my father fighting uh, as a Nishkam Karm Yog for the members of the community. So it gave me a lot of courage, it gave me a lot of passion, and I think that he became my role model and my everything, so that I can join the profession and be on the path of Hindu legal revolution. And therefore, we formed this organization called Hindu Front for Justice.
Right. Amazing, amazing. So your grandfather was also a lawyer.
My grandfather was a judge. He retired as an additional district judge. He was in the service of the judiciary. He retired in the year of 1975, and he was a very honest and upright judge. And my father also learned a lot of civil and criminal litigations through his eyes and his career and experience. And then ultimately, my mother is also a lawyer but not practicing. My sister is in academics in law. So we all were involved in some way or the other to contribute to the society.
So it is safe to say that it runs in your genes.
Yeah, I hope so. I think so.
Your dinner table conversations must be very interesting and intense,
Yeah, most of our dinner table conversations are into law and some aspects as something what new we can do, what something new ideas we can bring it up, something like if Ram Mandir case when my father was arguing in 2010. So it is at that point of time that I graduated in law. So I was the first person. I don't know. I was because I felt very proud that I am in the legal team of Lord Shri Ram. And it is at 2010 when I became part of that legal team. I assisted my father, and he was the one who argued revenue record extensively. I'm sorry. He argued revenue record extensively, that how in revenue record there has been interpolation. This point was put forward by him, that in the revenue records in Ram Mandir case, it was written Janmsthan Mandir. And at that point of time, Azam Khan was the Minister of Revenue. He interpolated the revenue records and he added Masjid Janmsthan.
Okay.
In where Janmsthan was written, revenue records were interpolated and Masjid word was added by him. So revenue record was argued by him. Then Article 13(1) was argued by him extensively before the Allahabad High Court, and he argued that whatever the invaders have done in the past, if it has to be rectified in the today's constitutional era, how it can be done.
So what is Article 13(1) about?
Article 13(1) says that whatever has happened before coming into force of the constitution, if any order, any sermon which has been passed by the then rulers or the invaders, if it hits any of the fundamental rights, it is in violation of Article 25 and it can be struck down.
Right.
So that was the argument, that if Babur has given any order or if Aurangzeb has given any order to demolish any temple, that order has a force of law in today's era also.
So it is placed, it's in conflict with Article 25. So this is specifically for religious freedom.
Yes, it is specifically for religious freedom, and this was argued that historical wrongs have to be remedied and have to be rectified, and if anything has happened in the past, those orders, those actions have to come to an end the moment the constitution takes a role on 15th August. And the moment we get independence and the moment the constitution is adopted and enacted, from that cutoff date, 26 January 1950, all those actions which have been done by the invaders in the past have to be brought down and have to be declared as unconstitutional. Okay. So this was the limb of the argument, and therefore this argument of historical wrong came into picture, which was not answered in detail by the Allahabad High Court, and ultimately the matter travelled to the Supreme Court. Before Supreme Court, my father raised this issue of historical wrong, how it has to be remedied, and then Mr. Parasaran also had argued this point, and ultimately the Supreme Court went on to answer that issue by saying that if there has been a historical wrong, it can be remedied by the sovereign of today's era. The sovereign, if he recognizes, sovereign means whoever is in power.
Right. So
in today's, they can, if they recognize that yes, something has happened in the past, an atrocity has happened in the past, and it has to be rectified or remedied, then the sovereign who is in power today can remedy it. So this was the answer to that argument, and therefore all this litigations we are fighting is in purview and in perception with that idea that judiciary is also one of the sovereigns. In our constitutional setup, the legislature as well as the judiciary are exercising sovereign functions. So if something has happened in the past, like Farman of Aurangzeb, which has happened in Kashi case, or like Farman of Kutubuddin Aibak in Qutub Minar case, like Farman of Muhammad Gauri in Bhoshala case, like Farman of various rulers in Tilewali Masjid case. So all these things, and like Farman of Aurangzeb in Krishna Janmabhumi's case. So all those orders have to be struck down by today's constitutional court by virtue of Article 13(1) read with Article 25 of the Constitution of India. So this is one of the limb of our arguments on the basis of which all these civil suits are pending before the court. Because the point is that when we are fighting all these civil cases in the civil court, we are taking court back to an era of 400 years back. We are trying to draw the attention of the honorable courts, whether it's the lower court, high court, or the Supreme Court. We are trying to draw their attention to the fact that something very atrocious has happened in the history. We are trying to draw the attention of the court that these places, whether it is Krishna Janmabhoomi, Kashi, whether it is Bhoshala, whether it is Tilewali Masjid, or many more temples, are of historical importance to us, have specific religious faith belief to us, are the center and epitome of our belief. It's the cradle of the civilization. And we are trying to draw the attention of the court to the reason that why these temples have been demolished. What is the reason and the psyche and the mentality before for demolishing these temples? Because the point is, and let me elaborate it a little further, that when you go into a war, the first thing which any enemy does is they want to attack and kill the king. Because the moment you kill the king, the entire army will fall to ground. So when the Mughals invaded India, in 1712, they came, looted, plundered and went away. But later on they realized, when Somnath temple was demolished and destroyed 12 times, they understood and they realized that our epicenter, our motherboard are these temples. And therefore these temples were demolished and destroyed. Because if you will read the history of temples in India as very nicely given by Mr. Sitaram Goyal and many more authors, the temples were not just part of our centers of our belief.
Correct.
The temples were part and center of our social integration. It was part of our educational integration. It was part of our cultural heritage and integration, and all the segments of the society used to come together, have food together, get education together, have a culture, have a common theme and line, and then we used to go to the part of spiritual success, spiritual achievement, and ultimately achieve salvation. So if you have to decimate a civilization, if you have to destroy a civilization, what is the first thing which has to be done? First, destroy the temple. So this is the reason we are trying to draw the attention of the court that this is not just an issue of a particular place. This is not just an issue of creating communal tensions in the society. This is an issue which is very deep and very sacred to us, because it's an issue of restoration of cultural heritage. Those places and those sites which have been demolished in the past, if it will not be restored in today's independent India, then when it will be done? And George Bernard Shaw said that a conquered nation is like a cancer. It can think of nothing else. So if you have conquered my nation at one point of time, and we were in slave era, as has been recorded by so many historians and so many politicians till date. So the point is that when will we get out of that chains of slavery? Why in places of worship act this cutoff date of 15th August 1947 is there? Because on 15th August 1947, we just got independence.
Political independence.
Pure political independence. The things had to follow. So how can you can say...
So essentially what you're saying is that this Article 13(1) of the Constitution is in opposition, is in conflict with the Places of Worship Act?
Places of Worship Act is in conflict with the Constitution.
Right.
Places of Worship Act is in violation of Article 13(1) as well as Article 25 of the Constitution of India, because actually everyone is misinterpreting Places of Worship Act. So my point is that why I'm saying is that Places of Worship Act is unconstitutional and illegal is for a very important and simple reason, that if we go by the interpretation given by the Muslim leaders as well as the Muslim community, what is their interpretation? That whatever has happened in the past has happened, and the cutoff date is 15th August 1947. And one very important sentence which everyone is missing is what? That you cannot go to the court to revive whatever has, or to restore whatever has happened in the past. That's the most important phrase, that you cannot approach the court. It says, article section 4 subclause 2 of the Places of Worship Act says that if anything has happened, if any suit is filed or revision or appeal is pending in the court, everything will abate, and only Ram Mandir was given as an exception. So first of all, if we go by this interpretation, I'm saying that I don't want to name anyone, but I heard some of the members of the Muslim community and their leaders were arguing that in Supreme Court, in Ram Mandir's case, secularism and Places of Worship Act was treated as a part of basic structure of the constitution. This was the argument. So you cannot take away Places of Worship Act because it now becomes part of the basic structure of the constitution. But you must analyze that how faulty this reasoning is, for a very simple reason, that in L. Chandra Kumar's case, 1997 Supreme Court, para 70 categorically says that judicial reviews the basic structure of the constitution, and 5 judges of the Supreme Court have said so. So you are taking my right to go to the court.
Absolutely.
If I want to go to the, if I have particular piece of evidence, if I have Farmans of Aurangzeb, if I have some pieces of evidence or historical books which have historical value by virtue of section 57 of the Indian Evidence Act, and if I want to go to the court and say, if I want to request the honorable judge that, sir, please look, there is something which has happened very wrong in 300 years back or 400 years back, and kindly see these documents and kindly try to restore it back, kindly give it back my glory, kindly restore the centers of my religious faith. The members of the Muslim community are not arguing on merits. They are not saying that whatever Vishnu Shankar Jain or Hari Shankar Jain are saying are erroneous. There is this evidence is incorrect. They are saying that, okay, you cannot go to the court. Just shut your mouth.
Right.
So the point is, I'm just explaining it in simple terms. So you are taking away my right to approach the court. So can this kind of approach be permitted in a healthy democracy? Can you say that, okay, whatever evidence you have is fine, but you cannot go to the court? And on the other hand, kindly see the obnoxious legal system of this country. On the other hand, the Waqf Act 1995 is enacted. Under the Waqf Act 1995, you have the power to declare any place as Waqf property. You have the power under section 52 and 53 of the Waqf Act 1995 to tell the DM and the SSP to evict someone who is an encroacher on your property. You don't have to file a civil case. Under the Waqf Act, the members of the Waqf board and the Mutwallis are public servants. So I ask a question, whether any Pujari, Purohit, any Shankaracharya is a public servant by any stretch of imagination under Indian regime? The answer is no. Under the Waqf Act, you have the provision that you can direct the administration to evict someone who is an encroacher of your property under section 50 to 53. And if someone encroaches a property of a Hindu temple, you have to fight a long legal battle under section 40 subclause 3. Very interesting section, I'm telling you. You have the power to declare any place as a Waqf property under section 40 subclause 3. And kindly see the atrocious provision. You don't have to inform the person whose property you are declaring as the Waqf property. If suppose you are a society registered and you have a particular piece of land somewhere, and if your property is declared as the Waqf property, what does section 40 subclause 3 says? That the moment your property is declared as Waqf property, Mr. Dhar will not be told that, sir, your property has been declared as a Waqf property. Your organization under which you are registered under the society, like the societies, the registrar of the societies, he will be informed. They are not obliged to talk to you also. The registrar of the society will be told that his property has been declared as a Waqf property, and we all know what happens in the registrar of the societies. There are 1,000 number of applications. It's thrown to the dustbin. So ultimately your property will be declared as Waqf property and you will not know. Taj Mahal has been declared as the Waqf property by the Waqf board in 2005. The Archaeological Survey of India is under appeal before the Supreme Court, and the Supreme Court is time and again asking that where is the Waqf deed given by Shah Jahan. So why I am telling you all these stories and all these legal propositions is that kindly see the inequality which is perpetrating in this country. For a majority community, for a particular segment of the society who wants to get their centers of faith restored, you say, no, it cannot be done because it will destroy secularism. On the other hand, you have all the powers to declare any place as Waqf property, and against that, if some person is aggrieved, they will go to the Waqf tribunal, which again is an atrocious body. Then against that order, you will go to the High Court and you will go to the Supreme Court. So my point is, for them, a judicial review, a judicial remedy, a chain of judicial forums are open, and for us, no forum.
Absolutely.
For us, there is no forum. So can this kind of law subsist in any healthy democracy? Can this kind of mockery of a majority community or of our faith can happen in any constitutional setup? And I am saying, forget about majority or minority community. It's a issue of essential legal rights. The right to approach the court. If something has been done by the parliament or by the executive, where will I go? In a constitutional setup, there are three tiers. There is three-tier mechanism. I can approach the court and I can tell the court that this illegal act has been done. But what the Muslim community is arguing in Kashi case, that you cannot go to the court. And let me tell you a very important fact. In Kashi Vishwanath case, one Mr. Vijay Shankar Rastogi had filed a civil suit in 1991, the first civil suit by the Hindus, and that civil suit was objected initially by the Muslims on the ground that it is barred by the Places of Worship Act. Ultimately, the civil judge took a view that yes, it is barred by the Places of Worship Act and the suit cannot move forward. He went in appeal before the district judge of the Varanasi court. The district judge took a view the religious character has to be determined, and there is what my second argument is while I am dealing with this issue of Places of Worship Act. I will come to that. The district judge took the view that religious character has to be determined and this suit is not barred by the Places of Worship Act. Against that, the Muslims went in revision before the Allahabad High Court in 1997, and from 1997 till date, which is around 25 years, the matter is pending in the Allahabad High Court on a small issue that whether the suit is maintainable or not. Evidence, the stage of evidence, framing of issues, local commission inspections have not arisen. Before that only, you are making me fight on the issue of Places of Worship Act. And whenever Allahabad High Court the matter listed before the Allahabad High Court on 6th of July, on day-to-day hearing, whenever that issue will be decided, they will come to the Supreme Court. And again, a huge lecture and sermons will be given to all the members of the Hindu community on the issue of secularism. So the point is that when I'm saying you, it means the members of the Muslim community, you have not argued on the merits of the case till date from past 30 years, that whether you have demolished the temple or not. You have not argued on the evidence of the case which we are trying to project. You are not talking anything about the issue of Shivling. You are not talking anything about the issue of the local inspection which has happened. But you are saying that it is all things are barred by the Place of Worship Act, and same thing is happening with us in our case.
This is very, this reflects very, very poorly on the judiciary of India, as well as the legislature does not have a great name for itself anyway. but it is, it's very worrying this way, because then the last resort that any citizen of India has is the judiciary, right? If everything goes wrong, at least you have the courts where you can appeal. Forget about if it takes 30 years, 40 years, 50 years, come se come, there is someone to listen to you. But with this Places of Worship Act, you are denying that, absolutely. Now, what that brings to my mind is the question of how, because you were involved in the Ram Janmabhoomi case. So, as I understand it, and please correct me if I'm wrong, the case was fought on the issue of adverse possession, ultimately, right? Which means that this whole debate about the civilizational importance, although politically, of course, the narrative was about getting it back and, the importance of the Janmasthan itself and how Shri Ram is so important as a civilization, as a religious icon, as God himself, right? But when it is fought on the basis of whether, a particular community had a continuous occupation of that place, and then it becomes like a kirai ke makan mein, right? So you have adverse possession there, and similarly you had to prove that there is no case for the Muslim community to claim that we've had a continuous worship there, right? So does that not reduce the weight of the whole, case?
See, in Ram Mandir case, the aspect of adverse possession was not that. I'm saying that was then argument raised by the Muslims. The suit number 4, which is the suit filed by the Sunni Central Waqf Board, they had claimed adverse possession. There were rest other 4 suits which were filed by the members of the Hindu community as well as the Nirmohi Akhada. Gopal Singh Visharad was the first who filed the suit for Puja Ka Adhikar, right to worship, in 1950, and then in 1989 Devkinandan Agarwal filed a suit seeking title of the entire area. So adverse possession was a plea taken by the Muslims, and you have asked a very important question, that if what is the law of adverse possession? The law of adverse possession is that, first of all, if you are claiming adverse possession, it admits the fact that you are not the true owner. Because adverse possession is that your possession has become adverse to the title of the true owner. The law of adverse possession is that if I am silent on a property of mine and for 12 years I know that someone is occupying my property and I keep mum, then the law of adverse possession triggers into motion. So the first of all, if Muslims are saying that they are claiming title by way of adverse possession, they admit that they are not the true owners of this property, and this is precisely our argument. This was precisely our argument in Ram Mandir's case. Second of all, the law of adverse possession cannot be against the deity, because Hindu deity is a minor and a juristic personality. It can be sued through the next friend, and therefore if you'll see the case filed by Mr. Devkinandan Agarwal in 1989, he took this plea, and this was argued by in the Supreme Court also, that Hindu deity is a juristic entity and a minor, and against a minor you cannot take the plea of adverse possession. And third of all, in Ram Mandir's case, if I'll talk about a holistic view of the Ram Mandir's case, there was a small lacuna in the sense that there was no direct evidence by any historian of demolition of a Hindu temple. And therefore, to prove that there was a demolition of Hindu temple, what we relied upon? We relied upon the inscriptions which were there in that mosque, which said, "Ye farishton ki utarne ki jagah hai." Then we relied upon Aine Akbari, which was written in 1583, which said that in Ram Navami people go and assemble there and gather and they worship their Lord Ram. Then we had the travel account of Trifenteller, Buchanan, and so on and so forth. Then we had other oral evidences of the residents of Ayodhya. And one very important piece of evidence which we argued before the Supreme Court, and precisely Mr. Hari Shankar Jain, he said that from 1528 till 1853, there is no evidence of any sign of Muslim worship in that property in question. On the other hand, on the contrary, there is evidence of Hindus worshipping in that entire area in question. And it is only in 1853 and 1858 ultimately, when Britishers came there, they put a railing in the property in question, and ultimately the Hindus started worshipping on the left side, the Muslims started offering namaz on the right side. It is only in 1858 this controversy has erupted. Before that, the history is silent. There is not even a single evidence. I am telling it with a lot of sense of authority. There is not even a single evidence adduced by the Muslim side that after 1528 until 1858 were they offering namaz there in the property in question, or was there any possession of them. On the other hand, as I told you, that there is obtain number of evidences that there was a temple existing. In Guru Nanak's in Sikh Itihas, Guru Nanak has visited that property in 1510, and he said that he took bath in Saryu river, and ultimately he worshipped the temple. And then the historical and then the mythological evidence comes into picture of Ayodhya Mahatma and all these things where it is mentioned that if you go and take a dip in holy Saryu river and then you worship Lord Ram, you achieve salvation. If you worship the birthplace, you achieve salvation. So the point is, in Ram Mandir's case, the argument of adverse possession was a self goal by the Muslims. And therefore, this entire concept of adverse possession is against Article 300 of the Constitution. It is against right to property. If I have a particular, I am against this theme and concept of adverse possession, and at some point of time I'll challenge the constitutional validity of this concept of adverse possession. Because if I have a particular property, whether I am there in possession of it or not, you cannot say that if you will usurp my land, if you will take forceful possession of my land, and if I keep mum, the law of adverse possession will trigger into picture. It will give rise to musclemen. Can you imagine this kind of law in a country, in our country, that if I have a particular piece of land, and suppose, take an example, that there are certain musclemen who ask me not to speak, otherwise they'll kill me, and they take possession of my property, and they are in the possession of my property for 12 years, I lose my right, I lose my title. So can there be this kind of law in an independent India? So these are the questions which have to be answered in future. But precisely to answer your question, so far as the Ram Mandir case is concerned, adverse possession was a self goal by Muslims, and adverse possession can never be asked against the Hindu deity.
Right. So, when it comes to the Kashi Vishwanath case, right, the Gyanwapi Temple case, and I use the word temple deliberately, right? So, in the Gyanwapi Temple case, the shivling was found, right, and now there is a lot of debate going on whether it is a shivling or not. So, tell us the inside story. How did it get started? I mean, who ordered the ASI excavation? Were you involved with that, or did you get involved later or at a different point of time?
See, I was involved in Gyanwapi case from the beginning, because me and my father drafted this petition filed by these 5 women, and the theme was that we want our right to worship there, and to assert our right to worship, there are certain important aspects which have to be determined as to whether whatever we are asserting is correct or not, and what is the situation on ground. With this theme and with this concept, with this background, we filed this application for local inspection of inspection by the Advocate Commissioner under Order 26 Rule 10 of the CPC, which provides so. So when we filed this application for local inspection, it was allowed by the Honorable Court, and Muslims had also participated in this entire case, which is civil suit number 693 of 2021. And they participated in the case. The Advocate Commissioner was ordered. After that, they raised this objection of Places of Worship Act. And let me tell you, by 5th of April order, the Honorable Judge said that we will see the aspect of Places of Worship Act, but first let us examine that what is the characteristic of property in question. Then thirdly, we asked for videography and photography of the entire area, which was ordered on 8th of April. Then against all these 3 orders, 18th of April, 5th of April and 8th of April, 18th of August, 5th of April and 8th of April, against all these 3 orders passed by the civil judge, they went in appeal before the Allahabad High Court. The Allahabad High Court rejected their petition on 21st of April 2022. Then they did not come to the Supreme Court. They participated in the local inspection, and after participating in the local inspection by the Advocate Commissioner, they raised this objection of biasness of the Advocate Commissioner, which was ultimately decided by the Honorable Court, saying that Ajay Kumar Mishra, who was the Advocate Commissioner, will remain in place. Apart from that, one more additional Advocate Commissioner was appointed, which is Mr. Vishal Singh. So when all these things happened and when we did the inspection, so as I told you that these 3 orders passed by the Honorable Civil Judge, Senior Division Varanasi, directing for appointment of Advocate Commissioner, rejecting the plea of first deciding the issue of Places of Worship Act, and third ordering for videography, and fourth ordering for entering the barricade of the area, was ultimately challenged by the Muslims, and which was rejected by the Allahabad High Court on 21st of April. They didn't approach the Supreme Court at that point of time. They participated in the proceedings of the commission, and while participating in the proceedings of the commission, very interesting thing happened. When Mr. Ajay Kumar Mishra was the Advocate Commissioner, sole Advocate Commissioner, so on 6th and 7th of May, we did the Advocate Commission of the external area of the mosque, so-called mosque, alleged mosque. So we found various signs of Hindu Devi Devtas, the Vigrah of Shringar Gauri, Ganesh Ji, the Vigrah of Devi Devtas on the western side of the mosque. And on 7th of May, Mr. Ajay Kumar Mishra, after doing the commission of the external areas, he tried to enter into the barricading, because only after entering the barricading you can enter in the mosque, otherwise you cannot enter into the so-called mosque. So then at that point of time the Muslims started shouting, the Muslim lawyers, and they said that this is biasness, this is biasness. So all of us said that what is biasness? What happened? We are complying with the orders of the court. How can you say that we are biased? So then they said, no, you are biased and we will not let this commission happen. And ultimately they challenged the appointment of Ajay Kumar Mishra before the Civil Justice Senior Division Varanasi, who ultimately said that no, he is not biased, we are not going to remove him, and they appointed another advocate commissioner. So when Mr. Vishal Singh was appointed and we did commission on these 3 days, which is 14th, 15th and 16th of this month of May. So there were, when we entered first time from this when this dispute has arisen, someone has legally entered into this so-called mosque complex, because initially the Hindus were in possession, which is categorically mentioned in Deen Muhammad's case. There is a long history of battle of Hindus for this property, which I'll deal with in the next segment of this entire episode. So when we entered into this entire area, first time in the Indian legal history, someone has entered into this barricading with the court's order. And after entering, the first thing which we did is we asked the Muslims to open the basement, which is basement number 1, which is in their possession, the keys of which are also in their possession. So when this basement was opened, very interestingly, we found that in lot of abundance, white paint has been done on a red stone pillar. The pillar is of a Hindu temple, which is very evident, which anyone can see. And on those red stone pillars, white painting has been done, oil painting, white painting, so that the characteristic of that Hindu pillar can be hidden. But from the pillar itself, you can see bells are made. In the pillar itself, it is made in a Hindu architecture, bells are made. There is alas in those pillars, which are places to keep sub-shrines. And those idols have been demolished. That also you can see कि छेनी हथौड़ी से वो मूर्तियां उन्होंने तोड़ रखी हैं. वो मूर्तियों का शेप बना हुआ है, वो आला बना हुआ है, पर उसको छेनी हथौड़ी से तोड़ रखा है. Then in that entire first basement, we have found a lot of symbols of Hindu temple. The pillars itself speak for it that the so-called mosque which is standing, that is standing on a pillar of a Hindu temple. Right. So this was the story of first basement. Then we went to the second basement, which is called Tehkhana of Vyasji, which is on the south side of this so-called mosque, and which is right in front of Nandi, which is in our possession, which is in the temple complex. Right.
Is this the same Vyasji, the Vyas family?
Yes. Same Vyas family. They used to do puja in that second basement till 1992. Wow. And it is only in 1992 they have been thrown out of possession, and this entire area has been barricaded. So if you can give me a paper, I can explain to you by a diagram, and for your viewers also. So this is the mosque. All right. This is the present temple. This is Nandi, facing towards this mosque, so-called mosque. All right. So now let me explain you the entire diagram, so that I think then I'll be able to make a lot of sense to you. Otherwise you will think that what I'm talking. So the point is this, that on the first and second day of the commission, we did commission of this entire external area. This is the western wall, where you will find all the you would have seen pictures where you can see evidently that this has all the remains of a pre-existing Hindu temple. So this commission was done on the 6th of May. And on the 7th of May, after doing this commission and commission of this area, and after demarcating the entire land, this is the gate, a small gate from which we enter into this property in question, which is the mosque complex. All right. So when we entered, this is the first basement, which was in possession of the Muslim side. This was opened, and as I told you that in this first basement we found the pillars. Then there is a small way which is going towards this area, and this is the Nandi, opposite Nandi. This is the second basement. Right. This place is the second basement.
This is the Vyas.
This is the Vyas. This was in the this was in possession of the Vyas family,
Right.
and only in 1992 they were thrown out of possession of this property, and this entire area was barricaded. Before that, there was no barricading. Before that, there was no barricading. It is only in 1992 the Vyas family was thrown out of possession of this property, and this entire area was barricaded. So we went into this second basement. In second basement, again we found pillars of Hindu temple. We found Sanskrit shloks. We found half-cut idols of Hindu Devi Devtas. We found alas which were there in the second basement. And then there were a lot of debris which was there in the second basement. And one very interesting thing has also happened. A local inspection has happened for this property on 30th of July 1996 by Mr. Vijay Shankar Rastogi. And at that point of time, it was recorded in that local inspection that this basement, in this first basement, the keys are with Muslims and they are not opening it. This time when they opened, so the truth is out. So the point I'm trying to make is that they did not go into this first basement in 1996 also. And second of all, this second basement also was locked in 1996 commission report, and later on when Vyasji was out of possession. But this time when we went, the doors were broken and it was full with debris.
Oh, which means that they've...
So which means that the evidence which was there has been tampered with.
Wow.
That is point number 2. Third point, after doing this second basement, then we again came back to this place. So there are 2 rooms here. I'm just talking about the ground floor of the mosque. There are 2 rooms here which is called as third basement and fourth basement. In this also these were all shops of Hindu temple where we used to distribute flowers and all, which were all painted into heavy, and those paints are also very fresh paint. These paints are very fresh paints. These are not paints which have been done from a long time. You can see that it is very freshly painted, and it has been mentioned in the Advocates Commission's report also. Then we, after doing these third basement and fourth basement, we went in the back side of the mosque, and we inspected this entire western wall. Then from this western wall, there is a gate here, a small gate here, which takes us to the terrace of the mosque, to the dome of the mosque. We went into the dome of the mosque. Inside the dome of the mosque, we entered into the dome of the mosque, because that dome of the mosque, if it is like this, it has a small window, so you can enter that dome. So inside that dome, we find another dome, which is the shikhar of a Hindu temple. So the shikhar of a Hindu temple has been cut, and above that, this present dome has been made. And this thing has been in all the 3 domes. So originally, if you will see, there's a map of James Precept, which said that this temple is of 8 mandaps. So 8 mandap temple was destroyed, and right now only 1 mandap is there. So this is the map of James Precept.
Right.
So this we have now, what remains as of now is this area. Rest everything has been destroyed. So this western wall on which these 3 domes are standing is of a Hindu temple.
Of course.
The western wall, all these 3 domes are existing upon that western wall, which is a Hindu temple. So inside these domes also there is dome, which you will never see in any Muslim architecture. Then we came down and we entered into the so-called mosque. In the so-called mosque, we found swastik inside the mosque. And same story, the mosque has been painted so heavily so that the red stone characteristic of that mosque can be taken away. Swastik is there, Trishul is there, and alas are there. Alas, like I'm saying, this shape alas are there, which are there in original Hindu temples, and in which sub-shrines and Devi Devtas, Ganesh ji, Parvati ji, and various idols of Hindu temples are there. So in this ala, now you can see somewhere pictures like this. So you can feel that the originally idol was there, which has been demolished, and now something it is like this. And all these things have been heavily painted into white color, yellow color, so that characteristic of a Hindu temple can be taken away. And one very interesting incident happened. Inside this so-called mosque, there was a calendar. The calendar of the mosque was Gyanwapi Masjid. When I took that calendar, जब उस कैलेंडर को उठाया तो उसके नीचे स्वास्तिक का चिन्ह बना हुआ था. And you know why this is happening? Because this entire area comes in the red zone.
Right.
No one is allowed even to take a pen or a pencil. So if there is swastik, how can you destroy it? So the only thing is to hide it by calendar. So these kind of things were done. Then after that, right opposite this so-called mosque and these three domes, these are the three domes which we inspected. Right opposite these three domes, this is the Wazu area. So when I saw the Wazu area, I requested the Advocate Commissioner to lower the water and see that what is there, because I saw in the middle of the Wazu area a wall like this. A wall like this, a circle wall like this. So I asked the Advocate Commissioner to lower the water because I wanted to inspect this area. So they said that this water is very sacred to us, you cannot enter this Wazu area. So then we took out a via media that we lower down the water and we'll take a ladder, we'll go here. So from here till here we took a ladder. We went there, and at the second day of commission, which is on 15th of May, this second day of Mr. Vishal Singh's commission, technically fourth day of the commission, because first 2 days external area, third day internal area, fourth day of the commission, only 5 days have happened. Fourth day of the commission, water was not lowered. So some members of the Nagar Nigam went inside, they touched the inside this well.
How deep was the well? How deep is
the well? This is not well. This is a well-shaped wall.
Right.
This is a well-shaped wall. This will be somewhere around 3 feet.
Okay.
Somewhere around 3 feet. So they touched something in the well and they said, "Sir, ये तो कुछ नहीं है, ऐसे ही है." Then Muslim also said that, "अरे कुछ नहीं है, इसमें कुछ नहीं है, उसको छोड़िए, हटिए." So I sensed something. That day also I sensed something, that something is wrong. So I told the Advocate Commissioner that you have 1 extra day. Let's give it a try. Because the court will assemble, so far as your report is concerned, on 18th of May. So you have an extra additional day. Let's give it a try. So he said that all right, tomorrow we will have commission only for 2 hours. Initially the time of the commission was from 8 to 10.
Right.
He said tomorrow we'll have only for 2 hours and then we'll close, Mr. Jain. It's enough. Nothing is there. Whatever you are claiming is all like this, and whatever report I have to prepare, I'll prepare and I'll send it to the court. It's enough. I said, all right, when we have an additional day, let's give it a try. So he said, okay. So on the third day of the commission, I said that please lower down the water of the Wazu area. So they said that in the water of Wazu, that in this Wazu area there are a lot of fishes. So fishes will get killed. So then we asked the administration to put oxygen in the water so that the fishes can remain. And then this water was of 3 feet height. So the water was lowered somewhere around 1 feet. The fishes were intact. No one was harmed. And then we went inside. When we went inside, I saw a shivling which the entire world saw. And one very interesting incident happened. The members of the Nagar Nigam were using bleaching powder. So they said, no, you can't use bleaching powder because fishes will die. So then they brought this pisi hui chini. And then they cleaned the shivling with pisi hui chini. And then it gives me goosebumps when I saw my Aradhya Dev in such a situation. And then and this shivling is right in front of Nandi. This Nandi which you are seeing in our temple complex. And the distance is 83 feet. 83 feet. Right opposite Nandi, this shivling is there. And then we went from this Wazu area. There is a small passage which is going down behind this shivling down. There is artificial wall here. It has been closed by artificial walls. And this shivling is going more deeper. When this artificial wall will be opened, then you will find the entire shape and the place where the water mechanism is there in a shivling.
So, is it your sense that this shivling is the original Vishwanath shivling?
See, this I cannot say. This no one can say. Because
there are other people from the Hindu side only who say that the original shivling is in the Razia Ki Masjid.
See, many historians have many versions. So therefore, because this property has been trampled upon by Qutubuddin Aibak, by Aurangzeb, some say that the priest and the Mahanji went with the shivling into the well. All these things are said. So what is there in the history precisely with different versions, as of now I cannot say.
Right.
But the point is, in the fact of the matter is that inside this mosque there is a shivling. And one very important feature to it also, which we must not forget: near this shivling, so called fountain by them and shivling by us, there is a well which is there in traditional Hindu temple, because from well's water the abhishek was done. So this entire area shows that it has all the ingredients of a Hindu temple. And when we saw the shivling, then the advocate commissioner took a very small stick, very patla stick, very thin stick, and he put it in the shivling. So there was a hole in the shivling of 63 centimeter, and this shivling is covered by some cement kind of material on the top, which everyone has seen. So ultimately the point is that in the so-called mosque, all the ingredients of Hindu temple is there. The western wall is there, the dome is there, the shivling is there, the swastik is there, the pillars are there, and this is just a local inspection.
Right.
Still one more inspection, which is the ASI survey, the ground penetration radar, everything has to be done. And one more very important facet of this mosque I want to tell you: in the middle of this mosque, in the central dome, beneath the central dome, when we did like this, so the sound which is coming right now, this sound was not coming. A very hollow sound was coming, which advocate commissioner has also written in his report,
Right.
that which shows that there is some more material down, for which we have to go. So ultimately it is for the ground penetration radar and the ASI to see. But the scope of this local advocate commissioner and this inspection was to bring before the knowledge of the court, to bring before the record of the honorable court, whatever is the thing which is existing on ground as of now. So ultimately this was the shivling which was used by them for wuzu and various other purposes. When I saw the shivling on 16th of May, it was Buddha Purnima and Monday, I immediately rushed to the court. I said that this area should be sealed, and as of now the position is that this entire wuzu area is sealed, and that order has been affirmed by the Honorable Supreme Court. So this is the aspect of this local inspection.
So there is, like, when we talk about the Ram Janmabhoomi case,
Yes.
Dr. Meenakshi Jain's book documents all the evidences and the literary, inscriptional, archaeological, all that. I think this is a very, very simple case as compared to that, right? That's my sense, and I don't think there is any dispute with regard to the origin. I mean, it being an original temple site. It's not just common knowledge; it is established, well established in historical records as well. So while it may take a long time to establish it legally, and we have capable people like you and your honorable father taking the lead, but as far as the truth is concerned, it will certainly prevail. But now the question of how do we juxtapose this with the Places of Worship Act?
Very important question you have asked. And now the question we have to determine is this. Very important question you have asked. There are two important aspects which flow from your question. First of all, let us see Places of Worship as it is. Whether the Places of Worship Act is unconstitutional, constitutional, that's the second debate. As of now, that's the law of the land. So as a lawyer, my duty is to interpret Places of Worship Act, and we have to see that in whose favor the Places of Worship Act is flowing. My contention and respectful submission is that in this case, in Gyanwapi's case, the Places of Worship Act is in my favor. And why I am saying so is that section 4 subclause 2 of the Places of Worship Act uses a word religious character. That whatever is the religious character of the property in question on 15th August 1947 will remain intact. So first of all, we have to determine that what is the religious character of the property. And as per the report of the local inspection, and as per the further report which will come as per section 45 of the Indian Evidence Act, we will prove by way of evidence. We will prove by way of evidence, which is already proven, but we will buttress our argument further that this property in question has all the ingredients of a Hindu temple. I am assuming for a moment that let there be no ASI. Suppose ASI survey is already ordered by the Civil Court of Varanasi. The Muslims are in appeal before the Allahabad High Court, and it takes a lot of time for the ASI to be ordered. As of now, the evidence which is on record before the Honorable Court in my case proves to the hilt that this entire place has all the essential ingredients of a Hindu temple. The western wall, the dome, the shivling, the tehkana of Vyasji, the pillars, the swastik, the trishul, and many more evidences, the kamal, the brahmchaks, everything proves to the hilt that this place has all the ingredients of a Hindu temple. So far as the Places of Worship Act is concerned, the religious character of this temple is in my favor, and you are the usurper, and you are in illegal occupation of a Hindu temple. See, the point is, we have to understand this notion that just by you coming and entering into a temple, and just by you coming and entering into a temple and offering namaz, it will not change the religious character of a temple. This we have to understand. You just enter into a property, convert it into a mosque, start offering namaz. Will the religious character of the temple be changed? The only answer can be no. By entering into a temple, by offering namaz, by converting it, the religious character of an essential Hindu temple will not change. And therefore, the Hindu law kicks into motion. And if you will see Ram Mandir's case, para 116 and 117, what does it say? That the vow, the obligation to create a temple, the sankalp to create a temple is having a legal force. So whoever has taken this sankalp, my Raja in the past, whenever it was demolished, whether it is Raja Todarmal or whether it is Vikramaditya or many more Rajas who have taken this sankalp to establish this temple, that sankalp has legal obligation. That sankalp will remain till the end of the time. So you come, you demolish my temple, but that sankalp will remain, and the essential ingredients of Hindu temple will remain.
But does that not, I'm just playing the devil's advocate here, does that not make the Places of Worship Act itself redundant? Because in any case, case of a temple being usurped by a mosque, so the essential character will always be the temple.
That's what our interpretation is, that Places of Worship Act does not, that's the second limb of argument apart from constitutionality. The Places of Worship Act does not trigger into the cases where there is illegal occupation or possession by members of one community over members of other communities. Suppose, for example, let's play devil's advocate, and if I give an example, today I go and enter into a masjid, I put an idol there, and I say that this idol was existing from 15th August 1947, and this mosque is now not a mosque, this is a temple. Will the members of Muslim community, will they not have the opportunity to come before the court of law and prove that this mosque was existing before installation of this idol? Will the members of Muslim community will not come to the court and say that this was all the essential ingredients of a masjid, this has wazu khana, this has places to offer namaz, this has Islamic architecture? And they will then only say that the Places of Worship Act is not attracted. And the same is the thing which we are doing. Places of Worship Act is the most misinterpreted law in this country, where people just believe that whatever has happened on 15th August 1947 and what is the religious character of a property will remain like that. So the point is, the religious character has to be determined, and that's why the civil suit is going on, to determine that the religious character of this property is of a Hindu temple, and therefore it should be given to the Hindus.
So when did they start offering namaz in this?
See, if you will read the judgment of Deen Muhammad judgment, first of all, I am not relying on it. Hindus are not parties to it. But it has some historical value because it's a part of legal history and it throws light so far as this entire controversy is concerned. So in Deen Muhammad judgment, you will find that post-demolition, which is on 16th April 1669, when Aurangzeb demolished this temple, and ultimately it was communicated to him that yes, temple at Vishwanath has been demolished. Post-demolition also, Hindus kept on worshipping this property in question. They kept on worshipping at the plinth of the mosque by believing that our idol, our Arad is there inside the mosque. This is mentioned by A.S. Altarikar in the book History of Banaras and other historians also of Banaras. So post-demolition also, there is lot of history of Hindus being in partly in possession of this property.
व्यास वाला तो clear ही है.
व्यास वाला clear है. 1898 में agreement हुआ था, which is mentioned in Deen Muhammad's case. And in 1898 the agreement was that beneath these mandaps, the three domes, which they call domes, which we call mandaps, beneath these three mandaps, they will offer namaz, and the other area will be in possession of the Hindus, and we will worship there. We will worship there. This was the agreement in 1899, agreed by the Muslims.
Right.
So if you will analyze Deen Muhammad judgment, two things come from Deen Muhammad's judgment. First of all, and that's why I'm trying to correlate that the Places of Worship Act argument is in our favor. Why I'm saying is for a very simple reason, that the idea was that the Muslims used to use this mosque as a Alvida mosque, just to offer Alvida namaz once a year, and to offer urs, that's also once in a year, because they had put graves in our temple complex. So slowly they started coming in high numbers to offer regular namazes here. So at that point of time, Hindus were in partial occupation of this property.
This is when?
This is post demolition. Okay. I'm talking about 1800s. Okay. This is mentioned in Deen Muhammad's case that from the time of 18th century, the Hindus were in possession half of the property, and half was used as a mosque by the Muslim side, and they used to enter from the western gate where Ma Shringar Gauri is there, do Alvida namaz and leave. Slowly their demand increased. They said that they need the entire property, and because they are coming in high numbers, so it is not possible to accommodate so many people in such a small structure, so they want the outer courtyard and the other areas. So in 1898, an agreement was entered into Hindus and Muslims, which is recorded in Deen Muhammad, and we said that in the outer courtyard the Hindus will remain, they will keep worshipping, and the Wazu area is in the outer courtyard. Where Shivling has been found is in the outer courtyard. So please keep this in mind, bear this in mind. So Hindus will be there in the outer courtyard, and the Muslims will keep offering namaz in the dome and in the structure. And it is on that footing that the area beneath the dome was declared as a Sunni Hanafi Waqf Masjid. So the point is, now if you see the property in question, I've been thrown out from there also. So if let us go by Places of Worship Act as it is. Section 3 of the Places of Worship Act says what? Section 3 of the Places of Worship Act says that after 15th August 1947, no one will change the area or character of the property. So first of all, if Muslims believe in Deen Muhammad and they rely on Deen Muhammad, because they say that this is a judgment in their favor, first of all they have to give us the possession of the outer courtyard. Today we have been thrown out from the outer courtyard, and Deen Muhammad's judgment was in 1936 and it was upheld by the Allahabad High Court in 1942. So very evidently till 1947, which is on 15th August 1947, we were in half possession of the property. Half of the portion of this property in question was in our possession. Question arises, why exemption is given to Ayodhya? Because the people started agitating for Ayodhya. That's why exemption was given to Ayodhya. So why can't exemption be given to other places of worship? Number 2. Number 3, religious character has to be determined. Number 4, if that religious character is determined and it's of a Hindu temple, it has to be given back. Number 5, if on 15th August 1947 we are in half of the area of the property, then section 3 of the Places of Worship Act triggers into picture, and we have to given as per the judgment of Deen Muhammad, the half of the area. And then we'll keep arguing that Deen Muhammad is illegal because we are not parties in this case. So if the Muslims are believing in Deen Muhammad, what they have to do is they have to give us this area. This area they have to give us. Right. And this was the position on 15th August 1947. This comes here only. So this area, this much area you have to give us. And this is in violation of section 3. Because section 3 says that after enactment of this provision, and therefore one very important piece I want to tell you, section 3 of the Places of Worship Act we have not challenged. Because section 3 says that after 15th August 1947, no one will convert a religious place into a place of worship of another faith. So we are agreeing with it. Yeah. That we don't want to convert any mosque into a temple, and we don't want any temple to be converted into a mosque. Very fair enough. But the problem is that section 3 has to be applied. Why the Muslims are not reading section 3 of the act? When we were there in the half of the possession of this area, this has to be given to us. Now because of this railing, we are completely out of the possession of the property in question. So Places of Worship Act has many facets to it, and if it will be read with the evidence and the judgment of Deen Muhammad, it will show that Hindus kept on fighting for our sacred piece of land. Hindus kept on fighting for this property in question. And see, historians and history will keep on confusing us with Razia Mosque or with this mosque or that mosque. But the point is that Shivling has been found here, and the ground penetration radar has to be done. If the ground penetration radar is done and this Shivling is ascertained by some government body that yes, this is a Shivling, then what will be the religious character of this property? When my deity is standing there, when my Aradhya is standing there, which is the mosque in the country? Tell me one mosque in this country where Shivling is standing and you say it's a mosque. Can it have all the religious characteristics of a mosque? So the point is that first of all, this Shivling has to be ascertained. People are filing petitions in the Allahabad High Court, and now obscene numbers of suits are filed. People are taking a stand of going and having a right to worship there. So the point is, ultimately it has to be determined that what Vishnu Shankar Jain and Hari Shankar Jain and the world thinks is a Shivling must be determined by the Archaeological Survey of India as a Shivling or not. And once it is determined by any government body that yes, this is a Shivling, then what will be the consequence which will flow? Then the consequence will be that this entire place cannot have a religious characteristic of a mosque, and the places of worship act will not attract here. And this is the precise reason that Muslims do not want to argue the case on merits. This is the precise reason they are saying that the suit is barred by places of worship act, this is against secularism, and shut the mouth here.
This is very, very similar to how the initial proceedings of the Ram case also happened, where they resorted to complete lies and outright mischief.
Yes.
There was no case to be made, and the whole media was in their favor, and they used to write long op-eds. And finally, as Dr. Meenakshi Jain has documented, when it came to actually giving testimonies, then they all claimed that we are not experts, we don't know.
Correct.
So I think it's going in a similar
It's an open and shut case.
Yeah.
I'm saying the moment the Shivling is ascertained, the moment the correctness of the Shivling, the how old the Shivling is, the carbon dating of the Shivling without damaging the Shivling is done, it will prove to hilt that this has all the essential ingredients of a Hindu temple. And one more thing, the right of deity will be created. The Hindu deity also has a right to be worshipped, to be given offer, bhog, prasad, puja.
So there is a demand already.
There is a demand already by yes, there is a demand already, and many Hindu priests are claiming this right, that when deity is standing there, then deity also has a right, because now this aspect I am telling you again and again, that now my deity is standing there. My deity is existing there. So the moment my deity is existing, it cannot have a structure, it cannot have a religious character of a mosque. It cannot have. So this has to be ascertained, and I think on this very issue, through your this esteemed platform, I want to give a suggestion also to the central government that just like Ram Janmabhoomi, a matter was referred to the 5 judges of the Supreme Court on the issue, which was a reference case, on the issue that whether a temple has been demolished and converted into a mosque. A small issue can be referred by the central government to the Supreme Court, and the issue is that whether this Shivling, which we allege and whether they allege as a mosque, whether this is a Shivling or not. First, let this exercise be completed. And the moment this exercise is completed, I think all the cases will fall to ground. Only one conclusion will come, that this has all the religious characteristics of a Hindu temple.
So the Vishwa Vedic Sanatan Sangh, this is an organization you were involved with.
Yes.
I believe in 7 cases.
Yes.
You and your esteemed father.
Yes.
Now there is a dissociation between you and them.
Yes.
So does that mean, like in some portals it was reported that your association with the case itself, which I doubt.
Yes.
I mean, so what is that controversy about? I mean, are you still working with them, or?
See, I'll just show you. So this is the suit filed by us of Rakhi Singh, which is the very highlighted suit. So this suit has 5 parties. Rakhi Singh, petitioner number 1, Lakshmi Devi, Sita Sahu, Manju Vyas, Rekha Pathak. So I am the lawyer for these 4 women.
Okay.
My Wakalatnama is on record for these 4 women. In the Varanasi Civil Court, I did not file Wakalatnama for Rakhi Singh.
Okay.
So the media and all the newspapers came up with this story that Vishnu Shankar Jain has been removed as a lawyer for Rakhi Singh. So when I am not the lawyer for Rakhi Singh,
just wanted to feel good about it.
yeah. So when I am not the lawyer for Rakhi Singh, how can I be removed? That is point number 1. Point number 2 is that my senior had an association with Mr. Jitin, with the Vishwa Vedic Sanatan Sangh, and he took a decision that he wants to engage another lawyer, which is fair enough. Everyone has a choice to have their own lawyers. So we are, my father is also representing the other 4 women. So the infight and this kind of projection that yes, they have been removed and this case has been completely demolished and they have been removed and now they can't contest this case, father son do, and all these things are going on. While the fact of the matter is that still on record we are the lawyers for the 4 women. So this is a fake news. This is a story which has been created to weaken the Hindu side. But let me tell you, the facts and the records speak for itself. And whatever a organization has taken a stand, that's the view of their organization. If Rakhi Singh wants to take a different stand, they want to withdraw the case, they want to take any stand, they are free to
So
take.
Rakhi Singh represents this Sanatan Sangh?
Yes, Rakhi Singh is the relative of Jiten Singh Vishen. And Rakhi Singh has given the stories like this. Jiten Singh Vishen has taken power of attorney from Rakhi Singh. And he is the president or somewhat of Vishwa Vaidya Sanatan Sangh. So he ultimately initially took a decision to withdraw the case. To which me and my father said that by no stretch of imagination we are going to withdraw the case. So only thing is that you can remove my father from the Wakalatnama of Rakhi Singh, but we are not going to withdraw the case. The other 4 women also had a categorical stand that come what may, till the end of the time, we are not going to withdraw the case. So if you have a stand that you want to withdraw the case, take NOC from us. Take NOC from us, engage another lawyer and argue whatever you want to argue in the court. But our case remains, our point remains, our issue remains, and just by giving NOC to Rakhi Singh, it does not mean that we are not the lawyers in this case.
Right. I think this is just muddying the waters and taking focus away from the main issue. Right. So actually, I had put a lot of other questions also regarding the Krishna Janmabhoomi case, but I think that, and also the Places of Worship Act. But like we discussed before the interview started, I think we should do one video with you on the Places of Worship Act, and then we'll deep dive into that in another time when you're available, and also the Krishna Janmabhoomi and other cases. But for giving us time today and explaining so much to us, this was really, really enlightening. And I hope that
pleasure is all mine, and I wish a lot of success for your esteemed platform. And what else I can say?
Thank you so much. Thank you.